am calling the meeting to order and ask for a motion to approve the agenda. That's pretty much just a review of the three proposals for policies relative to grievances and discipline.
I so move.
May I have a second?
I second, Kathy Belcher.
In favor?
Aye.
Okay. I think what I'd like to do, let me just say, I did, at request of several of you, invite Brooke Toomey to join us. Her brother is getting married tomorrow and they have their rehearsal dinner tonight. So she was hoping that she could join us for a short bit, but not sure about it. And I see we now have Dallas Cruz joining us. That's good. Welcome. Just called the meeting to order. So let me ask Jay if he can kind of walk us through where we are with the comments on these policies. And I'll let you take it at the pace you think is in the order in which you think is most appropriate, Jay.
Okay, very good. Well, first of all, I wanted to, let's just start up. I'll put the screen share again. We'll start up the page that has the appeals. I'd like to start on the appeals first. Let's see. I see what we close out. Is that the one I have to close out? No. I've got too many things open. Back to.
We have it up.
You have the appeals up?
Yeah.
Okay, good enough. So anyway, I just wanted to first go through an overview here. This is a policy that how to handle different forms of appeal, that we are anticipating the appeals as provided in the policies as both disciplinary and grievance, but there is a possibility always for some other type of evidentiary appeals. So you may see in here I include other evidentiary appeals. That's because I really don't know where it might go. There is a possibility in the future you may want to hook a policy into that, an appeal policy into there. So for instance, on EEOC complaints, when you get them, you might decide to hook it in. I'm not suggesting to do that. I'm just giving you the ability to it. So I'm trying to include it as broadly as possible. And throughout the course of the policy, I've used the term shall when we need something done, or may when we want to give flexibility to the board. So you'll see a lot of places in here I have indicated may, which gives flexibility all the way around. And I think that that's important because, for instance, if we designate that a notice appear on the website for a particular hearing and somebody forgets to put it up, and all of a sudden you're sitting down ready for this hearing and somebody says, oh wait, I didn't put it up on the internet, then that hearing is essentially invalid. You can't go forward if you mandate it. However, in the policy, if everybody's ready to go and it says may, you can say, okay, well, we're ready to start, let's go. So that's the reason why I've provided a lot of mays. And I also wanted to say, remember, these are appeals. You've gone through several layers in the organizational structure. You've gone from the employee to a supervisor, possibly up to head of personnel, possibly up to the CEO. So this is an appeal. We're not trying to craft something that's going to overcome what's already existed. We're trying to provide a safeguard for something that's very abnormal. In other words, you don't just go in and overturn the actions of the organization unless there's clear basis to do so. I would like to at least start. I would like to first start on the part that will probably give us the most trouble and give us the most discussion, and that is who will hear the appeal. So we have to decide as a group, or you have to decide as a group, is it going to be a 3-member panel? Is it going to be a 5-member panel? How many people we want to be involved in this? And secondly, who's going to designate it? Is it going to be the chair as we've created in here, or is it going to be the full board? The reason why I put a 3-member panel is that, first of all, for any time that you are going to be hearing evidence, you're going to want to have a quorum, and which is required, and you're going to want to have everybody who has listened to all of the evidence to render a decision. That means that if this is a 2-day hearing, and one day you have members 1 and 2 in, and the second day you have members 2 and 3 in, you can't have a quorum to provide a decision because everybody hasn't heard all of the evidence. That's why 3 members is the minimum that I can see that this would happen. And if you impose too many people, then you're going to have scheduling difficulties. And we're trying to make this a lot faster than with a 17-member board. And again, this is only to collect the evidence. Ultimately, the 17-member board is going to make the decision.
Well, but let's be honest about that.
Okay.
In all likelihood, at least the way this board has acted the last several years, the board is going to find with what comes out of this 3-member panel. Very, very rarely is there not at least a consensus. In almost every instance, it's unanimous that the board supports whatever decision a subcommittee puts forward. I can't think of a single time, in fact, since I joined the board 3 years ago, when the board has not agreed with a subcommittee.
Okay. However, it's never done it on an evidentiary finding when the board is supposed to make a decision, has it?
Well, we've only had one of these, so no, but I don't, why would you think that this specific instance would be any difference from any other decision that the board votes on?
I can't think of it. I would hope that they would support the panel, whoever heard it.
So would I. This is the reason I'm pushing for 5, and I completely understand your point, Jay, and I've been in that situation. 3 is far more convenient. It's easier to schedule. It's also easier to make sure that we maintain a quorum. However, I'm concerned, and I will tell you that I'm a statistician at heart. I'm concerned that a sample of 3 out of a board of 17 won't adequately represent the kind of the larger breadth and perspective of the board.
Okay. Well, then I'll put it out to other people that are part of the executive committee, which is not me. I'm just asking, are there other numbers other than 3 or 5 that, as proposed by Rob? Anybody wants more? Anybody wants less? Okay, then Chris, I think that
I'm inclined to think that we should keep the conversation between 3 and 5, considering the comments that we've received. There is one aspect to the 3-member board, 3-member panel that we haven't discussed, and that is that the board chair in appointing the committee can assess whether the people the chair wants to have on the committee are available and are free if the hearing should go on to multiple days. So it's easier to assure, not just easier to schedule, but easier to assure that the people you're calling can clear their calendars or hold them clear to hear the whole hearing. That's just one further argument for the 3, but it's not decisive.
Yeah, I think that's true. I'm just worried about choke points and I'm worried about optics. And if we have someone at a branch that is already skeptical about the broader process, and we have a single person appointing a very small group of people, I don't think that's going to engender the kind of confidence that we want.
Well, how about this? How about if we just say a panel between 3 and 5 members of the Board of Trustees will be appointed? And if it's a complicated issue, then we have 5 people. If it's something that's simpler to deal with, we have 3.
I mean, that's fine with me. My concern is if we're going to have 3, that there is some broader point of ingress for those 3 folks than because Chris may not always be the chair, right? He won't be. And we're setting policy, which is probably going to follow forever. So, or at least for the foreseeable future, right? So my thought is, let's either allow the chair to make up a larger, create a larger panel, or to allow another process that allows other folks to have input into the 3 that are seated.
Did I understand you to suggest the possibility, Rob, that we would put 3 in and give the chair discretion to increase it to 5?
That's one way. You could ask people to nominate the 3. You could ask people, I'm just looking for increased transparency, I guess.
Yeah. Thoughts from others, please.
I had just put my hand up just for perspective. I guess I have a question and a comment. One is, in the context of a 17-member board, I can understand where Rob is coming from, that 3 seems like a small number. But I would say that we're the 2nd largest board, even at 17 members in the state. Almost all are 7 or 9 members. And I guess my question is, for anyone who knows, but maybe Jay, is 3 a standard or a usual or a normal? And I know, Rob, you've even been involved with grievance procedures with your workplace. Has it been a 3-person panel, or have you even had a panel?
Rob?
We have a board. So I'm trying to think back at the current university. We have a board that is comprised of faculty and staff associated with the university, but has no, the board itself has no reporting lines for the purposes of the board. It reports to our board of trustees. So it's more of a peer review. But we also have things like faculty governance, which are probably the closest we have is the staff association, which doesn't have real, governance. As far as I know, Skip, please correct me if I'm wrong, but isn't really involved in the governance associated with the library system. So it's probably not a good analogy.
Okay, so the county has a personnel board of 5. And the reason it has that is because they specify that one has to be from the union, one has to be a non-rep, a person has to be from personnel, and so they split it, and a lawyer, and so they split it around in that fashion, and that's how they come up with 5. Most of the time, it's been my experience that 3 or 4 make it to a meeting, never 5. So, that's an issue on the county side.
So I'd be very concerned, Jay, if we had 3 people that were picked and only 2 of them made it to a meeting, for example. I mean, then we're talking about virtually no reasonable hope or expectation at a sample of a 17-person board. Whereas if we had 5 and only 4 made it to a meeting, we'd still be more representative than we would be with 3.
So if I'm hearing correctly, there's sort of an idea on the table, which would be instead of defining that, let's see, where it says who will hear the appeal, the chair of the board may designate a 3-member or a 5-member panel, and that would perhaps address both issues or both concerns.
Yeah, I think I'm comfortable with that at the chair's discretion. And I don't even know that we need to elucidate what the criteria are for selecting the 2 different sizes. I'm comfortable leaving that up to the chair. What I would say though is, if it's going to be, the instinct is probably if it's going to be a longer process, to go with the smaller. I would, as someone who just sat through what we sat through last time, I would be careful about that, because very rarely will you have complete participation in all of the sessions. So you really might need the larger group if you're going to have more than 2 or 3 meetings. Just a suggestion.
Okay.
This is a question, I think, for Jay. If the hearing should go multiple days and you have different people attending, but you have a quorum at each one, can we say that we've had a fair hearing if some of the people who are voting on the remedy at the end haven't heard all of the testimony?
No, I don't believe that if a person has missed the testimony, that they should be able to vote at the end.
Yeah, I mean, that makes sense to me too. And that's another problem with having a larger committee. But I'm happy to have the chair make a selection between the 2, because, for example, if I were doing this, I would be calling, let's just say I'd be calling 3 people for a panel. I'd make clear what I thought their expectations were and that I'd want all 3 present during those. And in appointing the chair of the panel, I'd hope I would be asking the chair of the panel to make sure that if the hearing goes beyond an initial date, that they find a day when everybody can be present.
So
That's
Chris,
probably a little more difficult with 5.
what if the concern, I'm also trying to see what would mitigate concerns by the staff. And I feel like I know the staff very, very well, having grown up where I did, having interacted with them the way I did, and having still so many friends on the staff. I will tell you that it varies widely, but there is some degree of distrust among the system, so to speak. Not individuals within the system, but the monolithic system. If we have 3 people that the board is picking, how are you going to warrant that your selection is fair, valid, and unbiased to the rank and file?
I think that's probably a problem with any panel whatsoever, and even the whole board to an extent. But I concede that would be more likely to be a problem with 3 than with 5.
Ms. Ellis would like to talk.
All right, I feel like I've been heard. I'm happy to go with what everyone else wants to. I mean, I made the points I want. If everyone thinks that 3 is the better way to go, I feel like I've had a fair hearing here, and I'm happy to move on.
Laura
wanted to speak.
Yes. So I've listened, and this is the first week of school, and I taught 5 classes today, so I'm a bit fatigued. But one of the things that I was concerned about is some of the things that have been talked about. And if it's a 5 panel and it takes longer, will the people be able to continue? So one of the things is that how does the chair select who's going to serve on the panel and who is the person who's in charge of the panel? Also, if we have people, do we need alternates? So let's say the chair selects 3 people, but one person can't make that, so maybe have an alternative. So let's say person A, B, and C are selected. They agree to do it, but before the hearing starts, B has something that one day has come up and they can't make it. So you already have person D and E as alternates, and those would be the people that would be at all the meetings. Because I do agree it's hard to testify. I mean, it's hard to make a judgment on something you don't hear unless all things are recorded. But to me, that's not as good either. So I think that was one of my concerns, is like, how do we, because, this process, how do we, the chair has a lot of power. And I'm like, well, what if a board member doesn't agree with the chair? I'm not saying a board member would or wouldn't, but I think that's why we're having this meeting, because people were like, and I know I was one of those people, I was like, well, why is this going this way? So, so the fact that I'm a part of this meeting and I'm able to hear more explanation and more concerns helps me feel more comfortable with the process. And I've read over all of the documentation. I haven't read all the comments. I'm sorry. The start of schools have been extremely bumpy because things are not in place as they should be, but we're making do. But so I feel a bit more comfortable about it, but I do agree with Rob. What is the criterion of being on a committee, or does it just rotate, or is it just by who's available? So that would make me feel more comfortable as well.
Well, Laura, let me just address your 3 points there. First of all, what would happen if, well, first of all, I would imagine that that Chris would call up the 3 members and say, do we have availability for September and before he designates these people. There's no problem with pre-screening people to make sure that they have availability. 2, I would expect the chairman would work with those other 2 people to find available spots. 3, if somebody just can't make it, there is nothing to stop the chair of the panel to say, okay, well, you're out. Let's get somebody else in here, and ask the chairman to appoint another person on the panel. I mean, putting up alternates just kind of keeps, I don't know about that. But to address your rotation question, that's a very good point, because, for instance, with the FOP and the police department, they have a list of names and they go through them. So we could actually do some kind of rotation system here, and not necessarily next in line, but if you served on one panel until everybody else serves on a panel, you won't be put back on a panel. Fairness, that's fair to you because you don't want to be sitting on all these panels. That's fair to the other people on the boat, because it gets different viewpoints involved.
Yeah, that makes a lot of sense to me.
I agree. I mean, why not create a randomized list initially, Chris, and then you can just work down the list. I mean, look, hopefully we're not going to need to do this at all. It's very rare. I think Skip runs a very fair ship, and we've seen that over and over. But why not create a random list, and then you can work down it as people agree or disagree or say they cannot participate, and then there is no there can be no complaint about bias. It's completely randomized.
Mm-hmm.
Well, I'm not even talking about randomized. I'm basically talking about once you've been on the panel, you get a strike through your name and you don't have to go again.
Sure, but why not start with a randomized list?
Because then you have the issue of, okay, the top 3 people and 2 can't make it on specific dates and everything.
Well, then you put a line through them and you move on to the next people. All I'm saying is that take the appearance of any bias at all to selecting certain people out of the equation, and then create a randomized list and make the selection criteria.
Yeah, I have a question, and I don't mean any disrespect to anybody, because I know so few people on the board personally. But I can imagine that there might be a panel without somebody that any of us would particularly think would make a strong chair. In other words, I think the chair of the panel could be a very important person. Now, you tell me, is everybody on the board capable of being a chair, so that if we had 3 people, none of whom have ever chaired a committee before on this board or maybe another, would we have concern that one of those would need to be a chair of the disciplinary panel, for example?
What if,
it's a question.
No, I think that's a very fair question.
It is.
What if you determined the chair after the 3 were selected?
I believe Chris indicated that what happens if none of the 3 are good to be a chair.
Well, I guess then my point is, then they probably shouldn't be on the list at all.
May I offer a compromise, and that would be that the chair of the board designate the chairman and the other 2 come off a randomized list.
You know what? That sounds great. I think, see, this is why we're so happy to have you with us, Jay. That seems very reasonable to me. And I don't know how everyone else feels about it, but I feel very comfortable with that moving forward.
Yeah, I do too.
Okay, so 3-member panel is okay?
Sounds good to me.
Okay. So I'm going to delete this comment, right? If I can figure out how to. There it goes.
You know what, Jay, I don't think you need to delete the comments now, because there's like 30 comments. You'll be all day deleting comments. I think if you can just make the change within the document, then we can go back and clean it up at the end.
What I'm going to do is I'm going to add something in this area, and I'm not going to come up with the language right now, but I'm going to add something here for appointment to the board panel.
Okay,
Okay, and then I'll send it out for everybody.
good.
Okay, that takes care of the hard part that I think. So I think we can go through this pretty fast. Here, top employment request and evidentiary appeal. How to address the appeal? Well, it says to the AACPL Board of Trustees. That should be sufficient. I don't want to get people on technicalities that you have to send it to the board. You can't send it to the supervisor or to the, I mean, I think we all are comfortable with you can request an appeal by any method as long as it's written. That's probably, it should be written.
Right.
Agreed?
Yes.
Okay. Okay.
Do we?
Jay, excuse me, I was just double checking where it says as specified in the 2 policies, it does say in writing there.
Okay.
So if you just leave it as it's specified in the 2 policies, you've got it covered.
Right.
Well,
Do you need to reference specifically that the employee has to exhaust, you know, the process before they can ask the board for some kind of relief?
Well, I think that's in those policies too.
that's in those policies.
Okay.
So this, as outlined, does cover it.
Okay,
And again, we don't want to slam any employee who has a valid appeal.
okay.
So we good on here?
Yeah,
Yep.
Okay. I'll take care of that. Do we want to include there? This one is Lonnie wanted reference to the exact policy numbers. Do you want me to include that?
sure. No harm. And if it's important to somebody, then by all means.
Okay. Okay, designate, we've already taken care of this. Chair of the panel, and may also designate, again, I use the word may. If we'll change this to will, would that be satisfactory? Chair of the board shall also designate. Well, I'll take care of it with the appointment to the panel, okay? But, okay, panel with conduct hearing and evidence, notes, artifacts, and records. It's up to you all if you want to have something done in terms of making it on the record, having it recorded and transcribed. I don't know if that's necessary, as long as somebody is designated to take the notes and deliver it in the report, because it's a report, it's what you're going to be dealing with. And I don't think that you need that expense, but it's up to this group.
So the output would just be the report.
Yes, sir.
What's in the back of my mind is, if this moves to a legal action, what do we need to do to be sure that we are adequately protected, like during discovery, for this process?
If it were moved to a legal action, and I can't imagine the basis that the grievance could be a legal action, I guess the discipline could be, because they do say unless there's a unanimity amongst the board members, and the head of Skip, help me.
Okay, so
The employee can take it to the state board.
in every by state law, in every grievance up to and including suspension of an employee, the action of the board is final.
Right.
In a case where an employee is dismissed and the board is not unanimous, then the employee has the right to appeal to the state library board. And that's the end of it there. And then they have the final action. So like Jay says, I don't know what legal basis there could be. Of course, if it's an EEO complaint or a discrimination complaint, that's a different matter. And we did have three of those, two of which went to trial juries that I think, Jay, were you the attorney trying those cases?
Yes.
Yeah, so we had two of those cases in 2011 and 12 that
But
went
they
to.
wouldn't be covered by this.
What's that?
They wouldn't be covered by this appeal policy.
Okay.
And EEO's case has to follow whatever's been addressed as their procedure.
Okay.
So it's not this way.
Jay, if you and Skip are comfortable with not doing this, I was just raising the issue. So if you're comfortable with the way it's stated, I'm fine as well.
Yeah, I am too.
I'm sorry, Chris, I forgot you're an attorney as well. I beg your pardon.
Well, the other thing is we can just record it and maintain it for the state librarian if you want. Shall we leave that open?
I think it's fine as it. I'm sorry. We're talking about. I'm sorry. I'm looking at my comments on my other one. Excuse me a second. A copy of the. Where is it? I'm sorry, I've lost track now of which one we're talking about.
We're talking about panel with conduct a hearing and take evidence. Rob says stipulate notes or other artifacts for records, and Jeremy indicates create internal templates, how to collect the evidence, but not have, it's not necessary to include in the policy.
Okay. I mean, I think we're fine.
Majority says fine.
Yeah,
Yep.
yeah.
So here we have a comment on request for postponement, a request for accommodation. Anything else we'd like to include? I'm not sure that there is anything else that would be handled pre-hearing, because this is pre-hearing. Does anybody else think that there is something that should be included other than a postponement or request for accommodation?
The sentence allows for more, and so I'm comfortable with those two unless somebody has a particular item that they'd want to add to that list.
Okay. Knowing that Rob has a limit, I want to keep moving on then. Written request must be given to the other party.
Let me just say, I contacted the provost and told him that I won't be at the meeting, so don't worry about me.
Thank you, Rob.
Thank you, Rob.
Do we need to specify other party? Do you want to say the employee or the CEO, or how do you want to deal with this, if at all? Is it important to deal with this one?
I kind of looked at that and I had a question, but I think the way it is leaves it open to interpretation for the specific case. Am I interpreting that correctly? Or can it be abused?
I don't think it can be abused. The only thing that I could imagine, I mean, a copy of the written request must be given to the other party. For the library, the other party is going to be the employee. That's an easy
Right.
one. For
Yeah, that's
a written request given to the library, I guess they could give it to director of personnel, the CEO, or somebody else. That's the only way it could be abused, or that we would lose it.
okay.
So
Well, then, I think that it's fine the way it is, now that we were discussing it, because I had some issues because I didn't understand, but reading it over, looking at the comments has really helped. So I think it's fine the way it is.
Okay. Other party by email. Do we want to provide, do we want to specify email or mail?
I think
we need
both
to-
should be a choice, because there may be people who don't have computer. I find it hard to believe, but I know that there are people who do not have computer service at home.
Yep.
So I think we probably should say email or US mail.
Yep. Agreed.
Okay. 10 calendar days. That was a comment here. Should we change it to calendar? Do you want me to specify 10 calendar days?
Yes.
Yeah, we should specify whatever we're
Right.
going to do. Calendar or
That seems adequate for it to arrive. If it's snail mail, you have to have, you have to have the ability for it to arrive in time.
Okay, I'll include calendar in there. When will hearing take place? Time will be given to the parties. Again,
Hey, I'm in a meeting. I'm sorry. I'm so sorry. I don't know if you can hear them in the background, but I can't. I am so sorry.
you can't see it.
Alex, I didn't understand what you were saying.
My apologies. I thought I was on mute and I received a phone call, so I just had to decline it. My apologies.
Oh, That was fine.
The one comment I'll make to Janie Lane, when she said 10 days should be enough if it's by mail. If it's by snail mail, US mail, it's really going to be 13 days because,
Really?
well, that's because it says a copy of the response must be given to the other party. The notice actually isn't given until 3 days after it's mailed. If it's
Oh,
by US mail. So you add the 3 days on top, right, Jay?
Yep, that's the court rules.
Well, then that sounds right.
Yeah, I think that gives us plenty of time.
So you want to do 10 calendar days? Or do you want me to add on additional days if sent by mail?
No, just calendar days, because I think it's already assumed that notice isn't given until 3 days after the notice has been mailed in
Okay,
the prior paragraph. So I think we're good with just saying 10 calendar days.
okay. The next comment was how will notice be given to the parties? I think that you were talking about requests being made by email or mail. I think that's kind of implied the same way. Doesn't matter which way as long as you give it to them. If you want to specify a method, I have no problem with it.
Yeah, whatever others want.
Okay, let's jump over that then and announce publicly, no problem in posting. Skip, we always post these right on the website. Did we post this meeting on the website?
Yes, we do. And we
Okay.
did post this one. Yes. Any open meeting of the board. Now, hang on just a second.
This would fall under the Open Meetings Act. So we would give notices to an open meetings. However, it becomes a personnel matter and close it.
Yeah, but
Yeah. So we do
you have
post
to
it.
have the open meeting in order to close it.
Yeah. So we do post it a week ahead on the website on the Board of Trustees page.
Okay, is there any separate procedure that you have that says that's to occur? Or is this just the way you do it?
This is how we have done it. And our previous attorney said this was a good way to do it. We also do post, I think it's on the day of the meeting on the front door of where a hearing is to take place, if assuming we're talking in person.
Okay, in the future, it might be a good idea to solidify the open meetings aspect. It's not something that we want to do here or ingrain it specifically in this policy, but it's just something that we might want to say instead of, if somebody asks us, this is normally the way we do it, say, this is the policy on open meetings. Just an idea.
Okay.
So this says allow change for good cause. I don't know how you can define good cause. If my mother is sick, then that's good cause. Good cause is used throughout the court system. I wouldn't know how to define all the potentials of what is good cause. So somebody has COVID and can't come in, that's good cause. I think that's a normally understood thing. Does anybody have a problem with the term good cause? Okay, moving on, no additional notice. The reason why I added that in is because if you're in one hearing and you say, okay, well, we're going to reconvene next week, same time, same station, and you'll not receive any further notice, that is something that's normally done in the court system, and I just adopted it through there. If we can put in there that the chair may notify people separately, but I'm not sure that that's necessary. Thoughts?
Hmm.
Discussion?
That seems fine to me.
So just to make sure I understand, you're saying that is being said to all the parties who are involved? Those would be the people who are most.
For instance, it would occur at a pretrial meeting or during a hearing by the chair. It said, okay, then September 1st, we're going to have this hearing. Everybody's cleared for it. There'll be no further notice. That's something that's normally done. So you'd have the library there and you'd have the employee there.
Okay, so the public doesn't need to know about that. Is that what you're saying?
That's different. We're talking about notice to the parties.
Okay, yes, I'm fine with that. Thank you for the clarification.
Okay. Moving on. Okay, so talking about this being in contradiction with the first two sentences, the first sentence indicates that, well, second sentence, the administration will present first in a disciplinary appeal and the employee will present first in grievance. Those are the two situations that we have good handles on that we know about. The reason why I included this sentence is whoever initiates another evidentiary appeal will present first in any other matter. That's what I'm trying to say, is that we're talking about not disciplinary, not a grievance. Does that make sense?
Could you give us an example, Jay?
No, I can't.
Okay, fair enough.
What I'm saying is there may be a time in the future where you want to create an evidentiary appeal for, say, if we go to our union, that there's going to be an issue over a union contract. You may want to create an evidentiary appeal there. We don't have that situation there. You can't anticipate every situation.
Okay.
That's out of an abundance of caution. I always leave it out. Decide who will win. It's a good point. Should we just, how will the panel decide?
Yeah, that's fine.
Because people didn't like the language.
I like that.
Okay, how will panel decide? Okay. A full report. Let's see. Do we want to attach a time frame? Time frame defined by last sentence. Board will consider the panel's report at the next regularly scheduled meeting after the hearing. Okay, we can include a time frame. If we include a time frame and the panel misses it for some reason, I mean, I personally like to see them getting a report to the board at least 10 days prior to a regularly scheduled meeting. However, if they miss that and say it's 9 days, then who are we going to punish? If the board misses it for some reason that's unavoidable, do we punish the employee by saying we're not going to make a decision? Is there a time frame that everybody feels should be the dead letter?
Well, I would like to review it before the actual meeting where I'd have to vote on it.
Absolutely. I agree. How much prior would you like to review it?
I would think 3 days would be enough for people to have time to review it.
The one thing I'd ask you to remember is that we have the entire summer off. So if we have something that follows our final meeting in the spring, late spring, early summer, that means we wouldn't vote on that until the middle of September, the earliest.
Yeah,
Yeah. It's, you could, instead of saying regularly scheduled meeting, you could just say the next meeting of the board, and that way.
That's a good idea. I like that.
Okay.
Yeah, that's good.
So
The next full meeting of the board or just the next meeting of the board? You know, we have the committee meetings and we have full board.
Yeah, next full board meeting. And just, you might even just say the next meeting of the board, because even if it's committees, you're gonna basically come together as the full board,
Yeah,
In the
that's,
beginning.
have this hearing.
yeah, that's true.
okay, so perhaps we change, the panel will forward the report to the board for review at least 3 days prior to the next full board meeting.
Yeah.
Okay. I can check on that now.
Yeah, that's good.
Okay. Any other comments regarding this policy?
I had one quick question, and I may have missed it. When you went over how will the panel decide who wins? In a disciplinary appeal, an employee must show that there is no reasonable support for the disciplinary action taken by AACPL. You may have said this, but so this says the employee. Can you just explain that? I'm sorry, you may have done it, but I may have missed it, or I may need to hear it again. I'm so sorry. Just having some clarity helps me so much.
That wasn't highlighted, so I didn't go over that. So generally, what we require, we support the action of operation, but if there's no support for it, in other words, if the library does not produce any support for that disciplinary action, then you would overrule that action. However, if there was any reasonable evidentiary support for that action, you don't want to substitute your judgment for that of library operation. Does that make sense?
Yes, I just needed some clarification. Thank you so much.
Okay. And the grievance is, whoever, proves by a preponderance, 50%. We're good? Any other comments on this?
Can you just clarify for me? So way further up at the top where we're talking 3 to 5 persons, and I think you didn't change it to adding in the 5. Are we only sticking with the 3-member panel?
I thought we had gone to the 3, but if you want to do a 3 to 5, that's.
No, I just want to make sure that I understood what the final decision was.
I'm listening, Chris. What was the final decision?
Well, I thought in the end, after we created the list off of which we'd work, the random list, that we decided on 3.
Yeah.
Okay. Okay.
Yeah, I thought it was that you would select the chair and then we would pick 2 others that randomly.
Yeah. I'll write up the appropriate language.
I mean, I'm not averse to alternates as well. If you want to select one alternate who would sit in on that in case someone is unable to participate, that's fine as well. But look, this may not happen. So I think it's possible to overthink it pretty easily.
Yeah.
Okay. So what's the decision on the alternates?
If I'm not mistaken, the alternates were going to be handled by just going down to the next person on the list.
Right. Yeah, there wouldn't be people sitting in on the hearing as alternate jurors, so to speak. But if we couldn't, if someone couldn't make it, we'd just take that person off the panel and put another one on.
Do you want me to put language of if a person cannot make it, if a member cannot make it?
I'm not sure you need any more language clarifying that. If you've stated that you're going to go to a list, then that's going to be a circumstantial matter to deal with as it comes up.
Okay, I see a lot of people shaking heads. So are we
I
all,
agree with, yeah,
are we all good with the policy when I change it and send it around tomorrow?
I
yeah.
think so.
Yes.
This one will be changed and sent around tomorrow. Let's go on to the next. Let's see. Okay, so evidence. Let me pull up the other one. Aggressive discipline, can I see that? Okay, shut that down, see if I get this aggressive discipline up now.
While you're looking at putting that up, I thought I might just express thanks to Laura for her comments. I think it was Laura, couldn't quite see from a great distance on the screen, but for her comments asking for a clearer language in the document. And I thought that Lonnie did a very nice job
Yeah,
of providing that. I think it was a very helpful comment of Laura's to get us to that point.
okay, so do we have, does everybody see the progressive discipline policy up there?
Yeah.
Okay, so when I initially tackled this, I didn't tackle this in order to rewrite it. I tackled it in order to make it in conformance with one, the law, and two, the new policy regarding appeals. So I would indicate to you, this is my comment, and when you're dealing with employee matters, you're dealing with either, and I know some of you already know this, so I'm sorry if I'm saying this and it doesn't make any sense to you, and I'm saying it to you, but you generally talk about performance and an evaluation, and discipline being somebody violated the rules. So those are two different things that we generally deal with. This is kind of like combined all together. I truly believe that at some point in time, all of these policies have to be worked on, massaged, to get into the same format, and also a little bit clarified. I am not the person to go headlong into these policies and do a thorough review of it. I don't have enough time. I really don't want to do it. So Skip, don't tell me to do it. But anyway, these are my comment is that this is a policy that needs to be worked on. The reason why I went into it is to deal with the issues regarding the 3-judge panel and a three-member panel, and as you will see, the reasons that you can discipline a person, which is, it comes under the public library section of state law. So again, I think that this is something that needs to be worked on, and not in final form, but it probably needs to be worked on at some point in time in the future, not now. We have this language that we should use pronouns they. Probably it should be done. We should at some point in time go through all these policies and revise them, because obviously this is an issue that the library has to deal with, as in many places do. I don't know if it's the time to do it here, because I don't know how many times we say she's.
Yeah, I'd be inclined to ask Coven to review all of the policies for this question of pronouns, and
Yes.
we address them all at once at a later date.
I think that's what I was trying to say. I'm sorry. Yeah, I didn't come to it clear.
I can take care of that.
Okay.
We've removed a lot of pronoun references altogether, and written it in another voice. Not because we're insensitive towards that, but because we're not sure where it's going to end up. So.
Right.
Yeah.
Okay. So we identify the 2 appeal processes that are available to the employee currently in the policy. You have a grievance policy and you have the suspension or dismissal. In looking at this, I don't know why we included this in here, because this only deals with the grievance policy. So I really question why this is included. But I think that what I was trying to do is just do a quick hit and take care of the staff association grievance procedure, which has been deleted. Does anybody have a problem if I delete this section from the grievance policy?
I don't see any reason to keep it.
No.
Okay. So I'll delete that there. Counseling and everything. Again, this probably needs to be rewritten at some point in time, but I think that at least at this point in time, we need to just pass over it. That would be my suggestion. Are we good with that? Okay, nobody's objecting. Going down, plan for improvement. Again, this is the same thing. This is where my review of the policy had a problem, and that is that it provided penalties and also why an employee can be suspended that was different than what was contained in the statute. So basically, we eliminated, we referenced the statute, we placed the suspension up to 10 days, which is according to the statute, and we indicated the 4 areas that suspension can occur.
Yeah, this is an area where we don't have any discretion. This is mandated by law, so we should put that in just as you've done it.
Yeah, the rudeness and swearing I wanted to keep in, but oh well.
Jay, if I may, I'm going to hold up a copy of the laws of Maryland. All of you received this document kind of as an insert in the, I think it was the front or back cover of your trustee manual when we had
That's
that
right.
session. And if you go to pages 20, 24 and 25, you will see these 4 items that are mandated in state law. So that'll give you the rationale for why we did this.
Yeah, thanks, Skip.
Okay. So the procedures here, as I indicated, procedure 1 is already spelled out in bullet 6 and 7. So it would be my recommendation that this be removed, unless somebody has other ideas. Okay. So I will take care of that. That just merely means I have to renumber and everything. Assign a verification statement, sign a statement indicating receipt of a letter. I don't know if what verification means. I just changed the language so that it makes more sense in the personnel actions I've seen. It shouldn't be a problem for most people. Here is where I inserted the procedures with the 3-member panel. So is there any problem with these changes? Okay. Dismissal, it goes through the same thing. We removed the different offenses and we put in the 4 offenses that you can be cited for under the statute. Verification, let's see, considering employing the sign, verifying, indicating receipt within 2 hours, 24 hours, probably 24 hours.
Why don't we take out the word verification again in that one?
Right. Okay. So do you think we need a time requirement here? I don't.
What happens if the employee refuses to sign?
Then you have a witness. Well, my experience is that you have a witness place a statement on the bottom of the dismissal letter. Employee refuses to sign. Letter was given to employee refuses to sign. I can certainly do that, but I think that Colvin would do that anyway.
Coven, why don't you mention what happens, because that has happened.
Yeah, it's exactly what Jay mentioned. Whenever an employee refuses to, sign something, not admitting, but accepting that document, we just write right at the bottom, the employee refuses to sign. And we always have 2 members of management meeting with the employee, so there's a witness.
Right.
Okay, I'm just going to write this verification, and that's going to tell me that I have to go back here and clear, make it sound consistent. And going farther down here, chair of the board may assign a 3-member panel of trustees which make recommendations to the full board for the action. Again, this is putting in place what we've already done. Let's see. I don't know. Oh, why are we? Will we be sharing with the employee the decision is unanimous or not? Will it be a public vote? It wouldn't be a public vote. However, the employee, as being a person in interest, would be able to attend the discussion. They wouldn't be able to attend the vote of the board of trustees. At least that's the way my experience is in these type of personnel actions.
So they can attend the deliberation?
They can attend the discussion. They can't attend the vote.
Oh, I see. Okay.
So
Thanks.
in other words, if there's any questions regarding the report that they are presented or anything like that, however, the discussions as to I'm voting for what and everything, that wouldn't be part of it.
Got it.
So no, but under this, the whether or not it's unanimous would be recorded. So, good question. Okay.
Jay, I had a question, and I'm sorry.
Don't apologize.
Okay, so under the procedures, and you may have said this, but I want to make sure. Under procedures B, procedures number 4, counseling may include a recommendation to meet with a counselor from the Employee Assistance Program. Is that a legal counsel? I don't know, or is that, I'm not quite sure what that means because I haven't reviewed that document. I apologize for that. Just wanted some clarification on that.
Can you direct me again?
It is under, it's under item, it's under use of disciplinary steps. It's item, oh goodness, where is it? Under B for procedures is page 5 of the document that was sent to us, item 4. It's right above item Roman numeral 3, suspension without pay.
Okay, so that counseling, where are you talking about what the counseling would be or what the?
Well, I just wanted to clarify, is that counseling legal counseling or is it not?
No,
I
no,
just didn't
no.
know.
It's in a personnel action, and in a personnel action, when you discuss with an employee and you counsel them, and you basically counsel them, you have to return to work on time, this and that, the other. And it may include a written counseling, it may include just a verbal counseling. It's basically a discussion between the employer and the employee as to the expectations and what happens if you don't go through with that.
I also think Coven might weigh in on that. If Laura, let me be sure I'm reading the right section. It says counseling may include a recommendation to meet with a counselor from the Employee Assistance Program.
Right.
So Coven, can you
Yes.
just say when that might happen and give some context for that?
So based on different scenarios or what may be going on with the employee, we may recommend that they speak with a professional from our employee assistance program to assist them with their problems. Whether it may be ongoing medical issues, mental health issues, family issues. We become aware of that, and then we generally recommend that they speak with someone at the employee assistance program.
And okay, thank you for that clarity, because from what I understand, what you're saying, that's to provide the employee with help to help them or support to help them meet the standards of their job and their performance. Am I understanding that correctly?
Correct.
Thank you for the clarification.
Right, and not only that, it just allows them to send them out to the EAP, because that's a very important program in order to get the employees the assistance they need. Sometimes you just can't offer that assistance on the job. They need some additional assistance. Okay, moving on here, I think that was the last. Yeah, I said verification, so we're going to straighten that out a bit. Let's see, considering deleting semen above 10 working days dismissal.
Yeah, I think you've covered it.
Okay. Oh, because this part is, yeah, okay. I think that takes care of that. Have an opportunity with the public before the board. We don't have an appeal for the hearing. Do we want to address this? Basically, it gives the employee the opportunity to I think this was left in there. I think 6 was left in there. I'm going to have to take a look at that, but I think that would be left in there. It may be incorrect. And I can put in here whether or not that the report of the Board of Library Trustees would have to say it was unanimous or not, but the minutes of the meeting would express that, would they not?
Yes.
Okay, so that's not necessary. I think that takes care of this section on dismissal or suspension. Does anybody have any questions? Does anybody want to make any comments?
Wouldn't there be an if the vote is not even, wouldn't if the word if be in front of if the decision is not unanimous? Down here, the next one down. Okay. Or if the decision is not unanimous, the employee may appeal to the State Board of Education.
How did I get it?
Don't you think that makes more sense? You
Yeah.
need it.
It is already at the beginning of point, number 7.
Oh,
so
you're
the board.
You're right. Never mind. Never mind.
So this should not be if?
No,
Okay.
I'm wrong. You already had your if at the very, very beginning.
I see, I see.
Well, don't forget to add back the T.
That's true.
Well,
Yeah.
The decision, yeah. Got it.
I keep going back and forth. Okay. Any other changes?
Nope.
Should I
Not for
move on
me.
to the next one? I'm sorry.
Yep.
Okay. Let me see if I can move on to the next one. I'll stop sharing the screen, and then we'll try to start sharing the next one, which is this staff grievance policy. Okay, let's go up to the top. Should be that strong one. Do you see the staff grievance policy?
Yes.
Okay. Okay. So I revised this portion of staff grievance policy with this is input. And the reason is the way the grievance policy was initially set up, basically the person could have it if he had his lunchtime pushed back half an hour, he could grieve it. If there was a not insufficient light in the room, he could grieve it. This language I pulled out of the county, which basically means that they can grieve anything that is against, that is an action of the library that's taken against the law or their own internal policies. So in other words, you can't grieve when your lunchtime is, but you can grieve when your lunchtime is if the policy says you will have lunch at noon. So if the library doesn't do something consistent with its policies, that's a grievable matter. If the library doesn't allow, whatever being posted in their office without permission, then that's not grievable. Did that help, or can I help describe it a little bit better? Anyway, that's what this is for, is to ensure that that the only things that can come up as a grievance is something that's really important. Some claim that the library is not doing something according to the law, according to its own policies.
Yeah, I think it's much clearer.
Okay.
And definite.
Let's see. Forms for grievance. Form available electronically. Okay. So it is available electronically. So that comment is covered.
I did have one concern
Okay.
under purpose. Hold on just a second. I'm sorry. Oops. I'm trying to make sure I don't have any background noise. That's why I'm keeping things on mute because I'm at home.
Coming back,
Oops.
returning to the break.
I'm sorry. What I wanted to ask was that first paragraph, if there is a dispute between a supervisor and an employee, and you don't have equal power, and a person feels intimidated to go to their supervisor, or if they've gone to their supervisor and they feel intimidated, is there another course of action for them to report a problem? Because there is a power issue there. You know what I'm saying? So I know I agree with, if the supervisor doesn't know about it, they can't handle it. But what if the person is very intimidated by their supervisor? Does the person is there another way that it can be reported without it blindsiding or superseding the person's supervisor, without going above their head? Am I making sense?
I understand what you're saying. That would have to be up to the library if they want to say there's going to be an ombudsman to discuss it between the employee and the supervisor, kind of to intervene. Is that what you're telling me?
So Coben is going to speak to this, but there is a whistleblower policy which is separate from this. And our equity design team is they're in the process of creating a method for anonymous reporting, primarily I'm not quite sure how to phrase it, but Coven, why don't you address this?
Well, yeah. Well, currently the process is, if the person is uncomfortable with speaking with their supervisor, basically you can go up through the chain of command. You have either a regional level, or on the support side, there's other various avenues that they can speak to, all the way up to myself, or even up to Skip, if they are feeling any type of intimidation or do not feel comfortable having a discussion with their manager. But as we're going through this equity audit, there is a process that will eventually be put in place that will allow someone to make an anonymous, raise an anonymous concern, or even vocalize their concern with some type of either equity officer or whatever the equity design team comes up with.
Okay, thank you.
Okay, so I guess we'll leave it as is now, and then we can possibly revisit it, or it may not be a reason to revisit it if the equity policy is sufficient. I think we're down to step one. Question is it verbal or written? And I see Coven's reply here about being verbal. Do we want to spell this out, or do we think this is sufficient? Coven, has anybody indicated that they had a problem with this college?
No, not at all. As I mentioned in a comment, generally it's always been verbal, that they've spoken with someone. When we have received any type of written notification, they've followed their chain of command by either including their manager or regional manager or anyone else that may be another step up in management.
Right, and I noticed in step two, they talk about filling out the grievance form. So we're going to get a written something in step two, and it's probably best to leave it the way it is so that somebody doesn't necessarily, no supervisor wants to be written up by their employee. If they have an employee coming forward and saying, I've got a problem, can we work it out? That's what we want to encourage. Agree?
Yeah, I think that's right. And we're leaving it up to the employee to decide how to bring it to the attention to the supervisor. So
Okay.
it could be orally, or it could be in writing.
So step five, we change it to the 3-member board, and that's it. So does anybody have a problem with this forum, problem information, anything else that we need to talk about regarding grievance policy?
Nope, not for me.
Okay, so what I'm going to do is I'm going to revise these and put them in final format and send them out to everybody here on the executive committee tomorrow morning.
That's
And-
good.
And then you all can talk about them. But in going through this, I think we have pretty much of a consensus that these are sufficient based upon the explanations and the changes. Is that correct?
Yeah, the object, of course, is to have something that we can bring to the, to give reasonable notice to the board for its meeting on September 15th. So Skip, I don't know what point you send that out, if it's a week before, 10 days before. Just
Yeah,
remind us.
we would want to send it out next Wednesday. So if everybody could review it, tomorrow or over the week, basically by Monday. Monday would be great to get Donna an opportunity to make sure it's in the right form, and that would be great.
Okay.
Since what I'd like to do is to bring a motion from the executive committee to the board, so we don't have to fiddle with that funny 2/3 requirement in the bylaws. How about if I ask whether we can have a motion to approve the changes subject to any change or correspondence that occurs among us in the next 6 days.
That
We have
makes
to-
sense.
Is that a motion, Jenny Lane?
Okay.
A second from Rob. Any discussion of that?
Do you
All in
have to
favor?
forego, I'm sorry, the 30-day rule? Is that what you're hoping to do?
Yeah, that's right. Just to be clear, the bylaws say that at any meeting, a proposal brought by a committee can be addressed at that meeting.
Right.
But if it's coming from an individual, not a committee, then it's got to go to the following meeting, unless 2/3 of the board waives that rule.
Okay.
So the idea was to kind of avoid that.
Okay.
But at the same time, I want to be sure everybody here has a chance to agree with the language that Jay's going to send us tomorrow. So it's a peculiar motion, I grant. But I think it would be good to know that that's what we're doing. We're recommending as an executive committee the 3 proposals that we've got on the table.
Mm-hmm.
So we're recommending it unless there's some objections and
Exactly.
further. Okay.
Yeah.
So
All
I
in
moved
favor?
it, Rob seconded it. So
Yeah. And any further discussion? Then all in favor? Aye.
aye.
Any opposed or abstentions? Okay. Well, I think we know what our marching orders are.
Mhm.
And I want to thank you for all of this, especially Jay for leading us through it. There were a lot of comments and I thought you handled them extremely well, Jay. And I appreciate the candor and the good questions and comments from everybody on the committee. Hopefully this will be something easy to explain to the rest of the board and to get it passed there. We will see how that comes out.
First, let me ask you this. Do you want me to do these 3 policy changes and then send it to the entire executive committee, or am I referring it to Skip to have it massaged and formatted by Donna?
You and Skip work that out. Whichever will, Skip, you know what that means. Whatever we can read best is what we need.
Yeah. Why don't you just, send it to me, Jay, and Donna and I can work with it tomorrow and get it out to the board tomorrow, maybe the afternoon, but that would be awesome.
Absolutely.
Okay. And thank you. I'd like to thank the executive committee too. I appreciate everybody's engagement on this. Thank you.
All right.
Thanks, folks.
Then may I have a motion to adjourn?
Motion to adjourn.
In a second,
Second.
all in favor?
Aye.
Thank you all.
Okay.